Hi, I'm Matthew from Frontline Law. In this video, I'm going to talk about something quite controversial, vaccine mandates. So vaccine mandates have been implemented in New Zealand over the last 2 years. They've actually now all been withdrawn, at least those that were imposed by the government, but there's still a handful of employers that require their employees to be vaccinated. In this video, I'm going to talk about some of the general principles that are relevant to the issue of vaccine mandates, as well as a case that Frontline Law was involved in against the government, in which we successfully challenged a vaccine mandate imposed on police and Defence Force workers. A vaccine mandate is the government or an employer telling workers they have to be vaccinated in order to continue doing certain work. In New Zealand, there's been vaccine mandates for health workers, corrections workers, customs, border workers, the Defence Force, the New Zealand Police, and others. There's also been mandates imposed by private workers, especially in the early days of the COVID pandemic when vaccines were first introduced. I'm going to start with the black letter law. This is something that everyone should agree on, and that is we're all entitled to rights under the New Zealand Bill of Rights Act. One of those rights is the right to refuse medical treatment, and there's no doubt that vaccination is medical treatment. So a vaccine mandate limits the right to refuse medical treatment because it involves a degree of coercion on the person who's subject to the mandate. Get vaccinated or lose your job. That's coercive, and the courts have agreed with that position. So the right is limited. In New Zealand, we have a New Zealand Bill of Rights Act that is like any other piece of law. And by that, I mean it's not supreme to other law. It's not like the US Constitution, which in the US, the courts can strike down laws that are inconsistent or incompatible with the US Constitution. We don't have that in New Zealand. We've got a Bill of Rights Act that's a normal piece of law. And that means that Parliament is free to make laws that do limit rights under our Bill of Rights Act. And that's okay. The courts can't do anything about it. However, the vaccine mandates that were imposed by the government were not passed by Parliament. They were secondary legislation made by a minister acting under delegated authority. This means that Parliament passed a law saying to a minister, you can make a COVID vaccine mandate for certain reasons, and then the minister could go out and do that. But it was a ministerial decision. It wasn't a law passed by Parliament that imposed the actual mandate. And this is really important because the courts can set aside a piece of secondary legislation, including an order made by a minister, if it is inconsistent with the New Zealand Bill of Rights Act. But it's not enough that it's just inconsistent with the New Zealand Bill of Rights Act. The limitation has to be unjustified. This means that for a limitation to be lawful and not set aside by the court, the Crown or the government has to satisfy the court the limitation is demonstrably justified in a free and democratic society. When the court looks at this question, they apply a test, and it's sometimes known as the Hanson or the Oaks test. And it's a multi-stage test, which I won't go through in detail, but I'm just going to talk about a couple of parts of the test that are particularly relevant to COVID orders or mandates. The first part of the test is that the objective has to be sufficiently important to justify the limitation. An example of an unimportant objective might be administrative convenience, meaning that the government can't pass a COVID mandate simply because they don't want to keep a list of who's vaccinated and who's not. In order to avoid the requirement to keep a list, they've just said, well, everyone should be vaccinated. That's not a good reason, and the courts would set that aside. But that's not what the government did in the case of COVID mandates in New Zealand. There were really two main reasons why the New Zealand government made COVID mandates. The first main reason was to prevent the spread and transmission of COVID. The second reason, which related only to a couple of workforces, was to maintain the operational effectiveness of those workforces, really meaning if people took sick leave because they got sick with COVID, that would lessen the operational effectiveness. So they wanted people to be vaccinated to minimise the amount of people taking sick leave. So that's the first part of the test. Is the objective sufficiently important? And it's hard to argue that preventing or limiting the spread and transmission of COVID, or to maintain the operational effectiveness of the police and defence force, is sufficiently important. I think it is sufficiently important, and the courts would agree. But that's not the end of the test. The next part of the test is that there has to be a rational connection between the limiting measure and the objective sought to be achieved. What that means is that the limiting measure, meaning the COVID mandate, has to actually achieve that objective. It's not enough that you have an objective but the measure doesn't achieve it, because that wouldn't justify the limiting measure. And it's up to the Crown to provide evidence to satisfy the court that there is this rational connection between the limiting measure, the COVID vaccine mandate, and the objective to be achieved. I'm going to talk now about a specific case that Frontline Law had, in which we represented a group of Defence Force and police workers. And this case was a High Court judicial review challenge, and it's become known as the Yardley decision. And the Yardley decision was the first successful challenge to a government vaccine mandate. It was in early 2021. So we had a group of police and Defence Force workers who the Minister for Workplace Relations, Minister Michael Wood, decided that he would impose a vaccine mandate on. He said that everyone in the police and in the Defence Force had to be vaccinated or they would lose their job. Now, initially the Minister said that the objective, the purpose of that mandate, was to slow the spread and transmission of COVID-19. And so when we challenged the order, the vaccine mandate in the court, that's the objective we were focused on, because that's what the Minister said it was. Amazingly, on the night before the High Court trial, we had a phone call and an email from the Crown saying, actually, we've made a drafting mistake. And the true objective of the mandate for police and defence force workers, it's not to slow the spread and transmission of COVID-19. In fact, it's to maintain the operational effectiveness of those organisations, of the police and the defence force. And this was unusual, to say the least, because the purpose of the order was the whole basis of it. And for the Minister to say, oh, there's been a drafting mistake, in fact it was a completely separate purpose, is very unusual. And it also caused us to do a little bit of last minute work prior to the High Court trial. So it was a late night that night. When we got to the High Court, we all agreed that it was sufficiently important to maintain the operational effectiveness of the police and the defence force. Those are organisations that keep us safe. They represent our interests in New Zealand and overseas. They're important. They need to be able to do their job. We agreed with that. But what the Crown couldn't do was present any evidence that a vaccine mandate would contribute or achieve operational effectiveness. And a big reason for this is because we were talking about a very small percentage of unvaccinated people. Most people had chosen to be vaccinated voluntarily. Only about 55 people in the Defence Force and about the same number in the New Zealand Police had chosen to remain unvaccinated. And those were for various reasons. Some had medical reasons they didn't want to be vaccinated. Some had religious reasons. Some had ethical reasons. Some kept their reasons to themselves. But all of them had genuinely held reasons that they didn't want to be vaccinated. The police and the Defence Force weren't able to show how dismissing 55 people from each organisation would have contributed in any meaningful way to the operational effectiveness of those organisations. And let me tell you why. As part of the court process, we requested a whole range of information from both organisations. For the Defence Force, we asked them how many people in the Defence Force were undeployable at any one time. And what we were told, the information we received, was that at any time, half of the Defence Force were undeployable internationally, and a third of the Defence Force were undeployable within New Zealand. That's a huge amount of Defence Force people that are undeployable at any one time. So there's about 14 or 15,000 people in the Defence Force, uniformed people. That means that about 7,500 were undeployable internationally, and probably about 4,000 or 5,000 were undeployable domestically. And yet the Defence Force and the government were saying they needed to dismiss 55 unvaccinated people because they weren't deployable at that moment, when they were willing to tolerate having thousands of people who are undeployable domestically and internationally. We said that just simply didn't make sense, and the court agreed. The police were in a similar position, but the challenge with the police is that, and the Defence Force, is that these workers spent most of their time during the day out of the working environment, going to the supermarket, looking after their families, doing stuff that wasn't connected with their work. Most of us only work 8, 9, 10 hours a day. We spend most of the day away from work in the community where there is no vaccine mandate. So how can you justify having a vaccine mandate at work when most of the time you're spending out of work, when there isn't a vaccine mandate and you're being exposed to vaccinated and unvaccinated people? That was another challenge for the Crown. There were a lot of legal arguments, and the hearing went on for a full day. But ultimately the court agreed with us that the vaccine mandate for the police and the Defence Force was unjustified. The Crown couldn't satisfy the court that the limitation on the right to refuse medical treatment and the other rights that were also engaged was demonstrably justified in a free and democratic society. So that was a great result for our clients and the group and all defence and police workers who would have lost their jobs had they remained, had we not gone to the High Court and had the High Court not set aside that order. And these are people who are in uniform, who serve New Zealand, who make huge sacrifices, often in terms of pay. Most could be earning greater pay in the civilian sector. In terms of time, they work shift work, they work long hours, they're away from their families. In terms of unpleasant working conditions, in the Defence Force, you might spend time in the field, living in the dirt under a tent, in a ship at sea, flying overseas on planes. In the police, you're dealing with violence, you're dealing with offenders, you're dealing with the parts of community that we don't want to deal with as non-police officers, and they go and do that for us. And so it was rewarding seeing this group of people who give so much to our community having their rights upheld by the High Court. So that's a brief overview of COVID vaccine mandates. The government mandates have now been withdrawn, which was the right decision made too late. There are still a handful of private employers who have their own vaccine mandates. We've seen those decrease a lot in the past months, but there are still a handful out there who have vaccine mandates. We think it's becoming increasingly difficult for employers to justify requiring their employees to be vaccinated. So if you or anyone you know is subject to a vaccine mandate and are unhappy with that and want to talk about your legal options, then give us a call at Frontline Law for a free initial consultation. Thanks for listening.